Okay, let's make a start. First, just want to say thank you so much for coming out. I know it's a busy time of year and some of you are doing exams and assessments and finishing up, but it was so great that you've made the effort to come tonight, so thank you so much as well. I want to begin by acknowledging we're gathering today in the lands of the Wurundjeri people and pay my respect to the elders past, present and emerging. You'll notice down here a piece of artwork I want to draw your attention to. That is a piece of artwork done by Alicia F. It's part of the Torch collection, which you may have heard of. If you haven't, Google The Torch. It's an important piece of work. The Torch supports Indigenous people who spent time in prison to then rehabilitate themselves through the use of artwork, with all proceeds going to those artists as well. So my students this semester came together, put in donations of $5, $10, $20, and they selected this piece of artwork, which we've got on display down here as well. Why is it important here? It's called Wari, meaning ocean in the Wadawurrung language. And to read the author's statement of intent, this painting expresses all the beautiful colours of coral in our ocean. The Great Barrier Reef is the largest coral reef in the world, right here on beautiful country Australia. It's 500,000 years old and has been around and taken care of and respected by a mob that time. In recent years, the Great Barrier Reef has been dying and in need of help. This painting shows a moment in the life of the beautiful reef and brings awareness to the beauty we need to upkeep as well. So I think it's a nice recognition of connection to the topic that César will talk about tonight, but also importantly today, you may have heard that our opposition leader decided he wouldn't appear in front of the Aboriginal flag. That in itself is an issue for us. I think I looked for an Aboriginal flag. I couldn't find one today. This is as close as I can get, but certainly want to make sure we acknowledge anyone amongst us today who is obviously a First Nations colleague, friend, and to make sure they feel welcome in this space as well. So this event is put on by a number of people. You'll see all these banners over here as well, the Melbourne Centre for Law and Environment, ILA, and the Melbourne Climate Futures as well, and the Human Rights Law Program at Melbourne Law School. It's a collaboration. I think it's an important thing to think about in this space as well. And we're really keen to do this event, even though it's late in the year, because today, in fact, is World Human Rights Day. Didn't actually know that. I don't think it made the front page of the paper this morning. You'll see in the back of this room a declaration of human rights adopted back 76 years ago now. The promise that he'd offered and hoped for hasn't perhaps materialised as we would have liked. And I suppose today's an important day to stop and reflect, not only on things happening to our own First Nations people, because there are many that aren't great, including, of course, what happened in Queensland just last week when they put to sort of end the inquiry into truth-telling as well. But of course, what's happening in Gaza, what's happening in Sudan, what happened in Melbourne at the synagogue on the weekend as well. There are many, many events that the day like us calls to reflect on and think about as well. But putting that to one side, I want to sort of bring our attention to my colleague and friend, César Rodríguez-Garavito. So I want to apologise firstly to César. I've just asked him to teach an intensive for the last 5 days, so he's just come off that. And most colleagues would say, thanks, John, but I'm a bit too tired. He didn't hesitate when I asked for him to do this lecture this evening as well. Now, when I was thinking about why I'd bring César into this classroom for you to listen to him, I often talk to my students about what are the qualities required for an effective human rights advocate. And there's a person by the name of Bernard Salt, which you may have heard of, a demographer in Australia, and he talks about the future belonging to people who are creative, caring and persuasive. César is one of those people. Sort of a rare specimen in a world where that doesn't always happen as well. And so I thought for me, it'd be wonderful to bring him into the law school, not just to teach our students, but also to speak to you tonight as well. So many of you will know that he's a professor of clinical law at NYU. He also chairs the Centre for Human Rights and Global Justice. Important in that space, he's really reinvigorated the entire way in which we think about human rights, which again, for me, is a real challenge professionally, but personally about how we think about the role of human rights in providing justice beyond the Anthropocene as well. So he's a founding director of Earth Rights Research and Action Clinic, which he teaches to his students at NYU. The More Than Human Rights program, which is about the rights beyond the Anthropocene as well. The Climate Law Accelerator, which is about litigation, the space we'll talk about tonight. And the Future of Rights and Governance, the Forge program at NYU. So César is one of these rare innovators in a space that requires innovation to realise the promises and expand, in fact, the promises of what the Declaration offered back in 1948 as well. He's what we call a field lawyer. He actually gets his hands dirty, both literally and physically, when it comes to litigating in a whole range of areas, and an earth rights and human rights scholar as well. His focuses are on climate change, international environmental law, Indigenous people's rights, and of course, more than human rights as well. His publications are far too long to list, but again, I'd really encourage you to engage with them those, and I'll actually provide them through email, perhaps to students and colleagues as well. Most recently, The More Than Human Rights, An Ecology of Law, Thought and Narrative for Earthly Flourishing has just been published by NYU. Litigating the climate emergency, how human rights courts and legalisation can bolster climate action, the topic of tonight's presentation. Human Rights 2030, existential challenges and a new paradigm for the field. So you can see César is a very, very busy person, which means we're even more fortunate having this evening as well. So tonight, I'd like him to introduce you to you and to welcome you to address the topic, climate change on trial, mobilising human rights litigation to accelerate climate action. Please make César very, very welcome. Thanks, César.
Thank you. Thanks, John, for the warm introduction and for welcoming me to the law school for the fourth time in person, and I think for the seventh time in a row, including the pandemic, teaching the class. Now, I am a bit tired, but I have no idea why some of my students are here, because they're equally tired and they should be tired of me as well by now. So I'm grateful for them to them for showing up. So today I do want to engage in a conversation. So I'll try to keep my comments to half an hour. And what I want to share with you is the result of an 8-year journey in climate and human rights research and practice. I first got in touch with the world of climate and human rights in 2016 when I was invited to participate in a workshop in São Paulo, Brazil, by a number of activists and scholars who were curious about the possibility of suing the Brazilian state for not doing enough against climate change. And this being Brazil, they were thinking about developing a case based on human rights arguments. The idea was to replicate the efforts that had been successfully pursued in the Netherlands recently, but a year earlier in the Agenda case, which I'm going to show you some images of. And ever since I've done research and practice, this is the type of work that I do. I'm really glad that John, with his usual generosity, picked up on this idea of a field lawyer, which I feel strongly about, because I feel that the best way to do human rights is by getting your hands dirty and go to the field and work with communities and be in places. My PhD is in sociology, so I'm very much not a desk lawyer, but a field lawyer. And also with my students, I tell them that there's nothing that I can teach them that they cannot learn by going to places like the Amazon or Bangladesh or Puerto Rico, like we are going to work on climate change and human rights impacts, because it's there where the climate impacts are happening. They're happening everywhere, but you have to get out there and work with those who are at the front lines of the climate impacts. So fast forward 8 years, and what was seen as a long shot back in 2016, meaning the idea of bringing corporations and governments to court for human rights violations associated with climate inaction, is now pretty mainstream. And this is, if there's one message that I want to send to this group today, is that the law can change very quickly. For those of you, I have no idea how many of you are in law school or have gone through law school, but the message that many students receive in law school is that things cannot change, that status quo is resilient, that it takes too long to change the law and institutions. Well, this is a story of a relatively fast change. It is a story, it's a 2-decade story that starts with the first complaint based on human rights arguments against the government for the impacts associated with climate change. It happened in 2005, and it was initiated, this complaint, by Inuit indigenous leaders in Alaska and Canada against the US. This was a complaint filed before the Inter-American Commission of Human Rights by Sheila Coutier and her lawyers in CL and Earth Justice, two great environmental organizations, in 2005. That's the first ever legal petition before a judicial or quasi-judicial body that try to hold accountable, in this case, a government, for continuing to emit carbon and to promote business models that incentivized dirty energy, meaning all these subsidies that are given and continue to be given to fossil fuel companies, which of course continue to pollute the planet. So And back then, I interviewed, in the context of doing research for this book, which is it's not this book. I'll show you the cover for the forthcoming book. This is a book that I did, by the way, with a group of around 20 practitioners and scholars based on a conference that we organized at NYU 4 years ago. And this was kind of a state of the art, taking stock of what this field of practice looked like back then in 2020. We held this conference on March 9th and 10th of 2020. So literally right before the pandemic hit, the second day we had to close the gates of the law school behind us because that was the end of the world as we knew it back then. But the good news about what we found out and we discussed in that convening is that by 2020, it was pretty clear that the idea of holding governments and corporations accountable for human rights violations associated with climate change had stuck. And this had become a professional and epistemic community of folks comparing notes, learning how to hold those actors accountable for those human rights violations. But this is 2020. I'm talking now about 2005. I interviewed the lawyers for the Inuit leader, Sherda Coutier, who was a petitioner in that case. And when they filed that case, they were looked down on by the mainstream. People thought that this was a very long shot, that climate change was not a human rights issue. Back then, only 20 years ago, climate change was seen as a thing that affected polar bears or the atmosphere, and that was not amenable to human rights language and norms. When the lawyers, went and asked for support from the large organizations like Human Rights Watch, they were given the cold shoulder. Human Rights Watch told them that this was not of interest to them because expanding litigation to climate change would dilute the message of human rights, that human rights was all about civil and political rights, and that climate change was best left to environmentalists, right? So the reason why I embarked on this action research project was because I was committed to litigation. I participated in that lawsuit in Brazil that it wasn't filed in 2016. It was eventually filed in 2019. But in the meantime, I also participated in another lawsuit in Colombia on behalf of young people. I'll show you some pictures from those lawsuits with colleagues at De Justicia, an NGO in Bogota, Colombia. That was the first successful legal challenge against the government on behalf of young people for the future impacts of climate change, which of course will hit hardest young generations and future generations. And that was 2017. So 2005 to 2016, Brazil, 2017, Colombia. And I remember that even then, during that workshop in Sao Paulo, and when we initiated this legal action in Colombia, this was still seen as a long shot. It was still seen with some suspicion, like as if this wasn't kind of the proper role of human rights lawyers. Fast forward to 2024, and everyone wants to file one of these cases, right? And you have 400 in the database that we keep at NYU, which, by the way, is open access. So anyone interested in this type of litigation can go to CLX, it's Climate Law Accelerator, CLX toolkit.org, and you can see all the cases that have been filed anywhere in the world for climate inaction based on human rights arguments, right? There are 410 such cases today. So it's definitely not fringe anymore. It's definitely not seen with suspicion. And this is the story that I decided to document more systematically after doing this edited volume. And what I'm going to show in the other slides in this presentation are the results of this more recent book that is forthcoming. So this is what the numbers look like. don't worry about the specifics. What's interesting is the explosion of cases is somewhere in the mid-2010s, right? It went from being something that lawyers with an inclination for innovation and thick skin filed in 2005 and in the 2000s, and then around the 2010s, number of cases start to explode to a peak of 77 in 2020. And now it's gone back, and actually this year it went down to 20. This is the number up to November 2024. The reason for this decrease is something that we're looking at, but what I'm interested in is in the upward trajectory and kind of in the stabilization of the field. Some of you may know, and I don't have time to go into the details of why this happened, but I'll flag two developments. One is the Paris Agreement in 2015. For those of you who do study law, you will know that the Paris Agreement is not binding in terms of the targets that it imposes on governments. It basically leaves the targets, the target of carbon emission cuts to the goodwill of governments. But it did provide an authoritative framework that was then and has been since invoked by domestic litigants as the source of the global target of global warming levels that are compatible with an inhabitable planet. As you may know, the target that is set by the Paris Agreement is for Earth to stay between 1.5 and 2 degrees of global warming. Sadly, we're going past 1.5. But even if it didn't itself, the Paris Agreement in itself set or create enforcement mechanisms, it did create a momentum around a number, a global target in terms of maximum global warming. Now, what it gained in terms of consensus on the target, it lacked in terms of implementation mechanisms. So Paris is very thin on showing the how to get to that level of global warming, maximum global warming. This is where litigation comes in. And the story of the 410 cases can be summarized as a story through which NGOs, environmental organizations, indigenous movements, youth collectives have taken governments and corporations to account to try to bring down that lofty promise of Paris in 2015 down to earth and to give traction to that promise. Because the promise itself has no binding force. So you see here, for those of you who are interested in international law or comparative law, you see here the interaction of international and national norms. The international system provides a baseline agreement, and then all the enforcement happens at the domestic level. I'll give you specific examples of the types of cases that I have in mind, but for now, I want you to get the broad picture. And then what also happened around this time is that the IPCC, the UN panel on climate change, started to be much more outspoken about the depth of the climate emergency. Right around 2018, it published a very concerning report about what it would mean for countries like the Pacific Island nations to go for the Earth to go past the 1.5 degrees of global warming mark. And armed with the tools of the Paris Agreement, or the language of the Paris Agreement, and the consensus, scientific consensus emerging from the IPCC reports, activists, movements, youth leaders from around the world sued one government after another. Not so many corporations, as I'll explain in a moment. There's a gap in accountability to this day, but this explains why we have cases throughout the world. This is the percentage distribution of cases per region. As you can see, Europe and Latin America. Oops. Europe and Latin America are the regions that have the largest number of cases, but there are also, I cannot go into details. I'm tempted to go into little details about why North America, why Asia Pacific, but I'll stay with the general numbers for now. Then also in terms of the outcomes, these are relatively young cases. So most of these cases, as you saw in the first slide, have been filed in the last 5 years or so. So many of them are still pending, right? More than half are still pending. So the jury is literally still out as about the outcomes of these cases. But for the cases that have ended in definitive rulings, this is a pretty surprising breakdown, because you would think that, given that many of these cases make pretty novel claims, as I'll show you in a moment, that courts would have been much more skeptical. The truth is that courts have been willing to entertain these cases and have found for the plaintiffs in almost a fifth of the cases, and for the defendants in almost 30% of the cases. These are some illustrations from some of the iconic cases. This is Urgenda in the Netherlands, the first case that successfully held a government to account for mitigation measures, meaning the emission cuts. Basically, what Urgenda, an environmental organization, managed to do was to get Dutch courts all the way to the Supreme Court to mandate that the government increase its emission cuts in line with the recommendations of scientists from the IPCC. This is the case in Colombia that I mentioned earlier. It was not the first case filed on behalf of young people, but it was the first case to succeed in that strategy. This is a well-known case in Germany from 2021, where the Constitution, this is probably the most solid ruling on climate change and human rights so far from the Constitutional Court of Germany, that ruled in favor of Lisa Neubauer, a Fridays for Future activist, and her co-plaintiffs, and mandated that the German state give more detail about the actions that it would take to attain the targets that it promised to hit by 2050 in terms of climate mitigation. Then this is a more recent case, and actually this picture is outdated. This is from 2021. This was the first successful case against a major fossil fuel company, Shell. So Milieu Defensive, Friends of the Earth, sued Shell and asked that Shell also bring its business model in line with what's needed in terms of the rapid decarbonization of the global economy by 2030, and according to the IPCC recommendations. The reason why this picture is outdated and this person is no longer as happy is because that ruling was reversed just 1 month ago. But the principle that corporations are accountable for climate for human rights violations associated with climate change, and that they do have responsibilities to cut down emissions, that was all upheld. What was reversed was the decision of the lower court to mandate a certain target by a certain time. So it took away kind of the legal traction and the practical traction of the case, but in principle, it upheld the lower court's ruling on principle. This is a very important case, and this is the lawsuit that I was involved in discussing the foundations for early in 2016. It was decided by the Supreme Court of Brazil in 2022. This is the author of the opinion, the current Chief Justice of Brazil, Antonio Barroso, Luis Roberto Barroso. And this was an action against the former Brazilian government that, as some of you may know, not only stood idle while the deforestation in the Amazon proceeded, but actually aided and abetted deforestation in the Amazon. So, and the government decided to sit on money that had been given to Brazil to fight deforestation by foreign governments to fight deforestation in the Amazon. So this was a case where the court mandated the government to use the money to fund deforestation, programs against deforestation in the Amazon. And importantly, this ruling declared that the Paris Agreement was indeed a human rights agreement because it has so many human rights repercussions that it should be treated for legal purposes as a human rights argument. In the US, there have been a number of lawsuits filed largely by a fantastic organization by the name of Our Children's Trust. Yeah. Most of them unsuccessful given what the US judicial system is like when it comes to dealing with these issues. It's quite conservative and it's not particularly receptive of human rights arguments. But this was the first highly successful case. This is a ruling from earlier this year against the state of Montana. And this is probably the most important international legal precedent. Also from this year, a decision of the European Court of Human Rights in a suit filed by an organization of elderly women. It's literally the name of the organization from Switzerland that sued the Swiss government for not doing enough against climate change, which in turn affects disproportionately elderly women. So this is an important precedent. Okay, so enough for illustrations and the law. What I'm going to do in the next few minutes is tell you more of a socio-legal story, right? What lies behind? How is it that a whole movement gets established? How is it that activists come together? How lawyers compare notes? How judges learn from each other and end up establishing kind of a veritable field of research and practice. So this is the forthcoming book that tells that story. It's more socio-legal than the previous one. Socio-legal meaning that I did a number of interviews. I went to those places. I drew on my own participant observation in many of the cases to tell more of a first-hand account of this story, of this 20-year story. I'm not going to be able to go into the details of each of these chapters of the book, but I'm happy to elaborate on any of them in the Q&A. Just so you know, the book looks into the origins, explains why it was that this idea caught on, right? How is it that what international law scholars and international relations scholars call norm entrepreneurs, meaning people who with new ideas, who take it upon themselves to talk to other individuals and to persist in pushing forward new legal doctrines and new ways of campaigning around issues, how those norm entrepreneurs manage to convince enough institutions, courts, activists, NGOs to file enough cases to give some momentum to this whole wave of litigation. Then I look at the actors. One very interesting feature of this, I come to this research and this type of practice, as John said, from a human rights and indigenous rights angle. This field is at the intersection of environmental law and human rights law. Most actors, in fact, the first meetings that I attended in preparation for some of these lawsuits were all dominated by environmental lawyers. Human rights lawyers were nowhere to be found. So it was the environmental law experts who really spearheaded the initial efforts. They were the innovators. And human rights, and this is a critical engagement with the human rights movement, as John kindly said, I've been trying to be kind of a constructive, critical voice inside the human rights movement, both in terms of scholarship and practice. I am not an end times of human rights scholar. I don't think that the game is over for human rights, but I do think that human rights need to, practitioners and scholars need to revamp kind of their tactical repertoire to face the challenges of fundamentally new issues like climate change. Climate change is not like any other human rights issue. It's planetary in nature, its temporality is non-linear, meaning as time goes by, it gets worse. There are tipping points. So if we don't do enough, very soon there will be tipping points of the bleaching of the coral reefs, of the drying of the Amazon, the melting of the ice sheets, and so on. So time is of the essence. So it's not like all human rights issues are urgent, but not all human rights issues get worse and categorically and qualitatively worse if we take long to address them, right? So it's not like healthcare, it's not like prison reform. As important as those issues are, they're not necessarily getting worse exponentially by the day as climate change is. So this means that for this type of legal challenge to succeed, scientists and lawyers have to collaborate. And one very encouraging feature of this field is that litigants have been very effective at mobilizing science before the courts. And my own program at NYU, CLX, has collaborated very closely with collectives of scientists like the Union of Concerned Scientists in the US. The Oxford Sustainable Law Program does the same with the scientists in Europe. So unlike other subfields of human rights practice where there's more kind of arm's length relationship or less of a fluid conversation between scientists and lawyers, this is very much a collaborative effort. Another promising feature, I also wanted to tell this story because I see it as a hopeful story of innovation and creativity. This, again, and it happened pretty quickly. So I'm not telling a rosy story of climate and human rights. There are challenges, there are blind spots, as you'll see in my last slide, but it's definitely a counterargument, a counterexample to the more pessimistic and fatalistic views of human rights. I've written before in that piece that John quoted in other places that scholars who have written kind of the obituary of human rights can do so because they do it out of the comfort of an ivory tower office in the US. If they took the time and effort to go to the field and work with activists and communities, they would have a different view, a more nuanced view, a more complicated view, which is one that I try to offer in this book. Another promising feature of this field then is that there are that many of these legal actions are pursued as collaborations between movements and lawyers. Many cases have been filed by the youth movement. We have worked with Fridays for Future, with the Global South Youth Movement on a number of cases. Our Children's Trust is a lawyers organization that has always worked very closely with the youth movement in the US. And organizations like Greenpeace have been absolutely fundamental to the growth of this field of practice. In fact, Greenpeace has filed at least 20 of these cases, and Greenpeace went as far as to create a legal division, a litigation division. Greenpeace is not a litigation organization, or didn't used to be, or it's continued, and to this day, it's not predominantly a litigation organization. It's a campaigning organization. They're well known not for suing, but for jumping on oil rigs and trying to block them from drilling oil from the Arctic, right? So but they early on, meaning in the mid 2000s, early 2010s, realized that they could mobilize the institutional architecture and the norms that human rights institutions had developed for 75 years then, or 70 years, or 65 years by then. And they say, well, this is ready-made. Let's mobilize it. If the human rights lawyers think that this is not, that this architecture is not helpful to address climate change, we'll do it ourselves. right? And this is exactly what they did. They've sued everyone from Norway for drilling for oil in the Arctic, to Spain, to Brazil. This case that I helped with in Brazil was partially supported by Greenpeace. So it's an collaborative effort between movements and technicians of the law, which is something promising and rare in other subfields of human rights. Then the book and the story that I tell also goes deep into, for those of you with more of a technical legal inclination, it looks at the new ideas, the new doctrines that have been developed by lawyers and courts to address those particularities of climate change. I'll end the presentation by mentioning a couple of those doctrines, just so you get a flavor for what I'm talking about, but I don't have the time to do a deep dive into any of them. And finally, because in the end, I'm a sociologist by training and also a lawyer, but also, and I'm interested in impact, in changing the world as much as understanding it. I look at what difference those decisions and those legal efforts, those legal actions have made or haven't made on the ground. So I look at impact, okay? Quickly, I think I'm gonna skip this. Well, I'm just gonna lay out the typology that I use in the book. I'm interested in capturing the full range of impacts of human rights lawsuits. Usually, both activists and researchers tend to focus on the direct material impact of the cases. Right? But by this, I mean the very tangible direct impacts that stem from the court's orders, right? So usually the direct impact here is the Dutch Supreme Court ordered the Dutch government to increase its mitigation target to 25% less carbon greenhouse gas emissions by 2030. I'm making this up. I don't remember the number by heart. And this is tangible in that it is you can see it in practice. And this is these two axes are pretty standard, right? So direct here versus indirect is simply a heuristic that I use to say, well, these are consequences that stem directly from the court's orders, and these are unintended indirect consequences. Right? Whereas here, I'm looking at the difference between tangible differences that you can see in practice, you can touch, and these are changes in perception. This is changes in reality, in material reality, changes in perceptions. The law and rulings and legal actions operate a kind of magic because the law reframes issues. If you advance, if you file one of these cases and name the displacement of a community from a coastal area as a human rights violations, that reframes the understanding of the situation. It's no longer a natural disaster. It is now a human rights violation that affects specific individuals. And even if you lose that case, the reframing of the situation can have political and social effects. So this is what I'm getting at with symbolic effects, right? Again, I'm not going to go into all the details, but as you can tell here, for example, many cases that end in rulings for the defendant, meaning that cases that the activists and the human rights lawyers lose, may end up catalyzing the formation of activist coalitions. So movements sometimes are catalyzed by legal actions, and that should count as an effect of litigation. So you get the idea, right? So I'm trying to capture the full range of impacts because looking at only this direct material effects, that's a disservice for the amount of work that goes into litigation, and also because oftentimes indeed, lawyers have these other effects very much in mind when they litigate. they know, some of them know that they will lose the case, but they're still interested in pursuing the case because of the media impact, because of the opportunity to reframe the issue as a human rights issue. I'll end with this and open it up for questions and conversation. What does this look like in practice? What is it that courts and lawyers have said that is new to the world of human rights law? Many things. I'll skip the first one. The second one is pretty well established by now. Courts, except in a few cases, have not said that governments have full discretion in acting or not acting against climate change. That this is not a political issue. This is another way to put it, right? Except in the US and except in a few cases in other jurisdictions, courts have said that human rights violations stemming from climate change are indeed justiciable issues. Right? This is pretty well established, but 410 cases have given us enough confidence to know that even courts who find for the defendant, for governments or corporations, say that they are prepared to review the actions or omissions of those actors, right? And so this is a very important doctrine. Then this has everything to do with what I said earlier. What courts have said in the most important rulings is that national laws, everything from constitutional law to administrative law to environmental law and human rights norms, can be used to enforce and to give traction to international promises on climate action, even if those promises are not binding themselves, right? So this is how the Paris Agreement has been domesticated and has been given traction at the domestic level in many cases. And finally, and this is just a sampling of the relevant doctrines, one common line of defense by government and corporate lawyers is that climate change is a planetary challenge, that no single actor, be it a government or a fossil fuel company, can solve it by itself. So the Netherlands says, and you will see one in other, I've read so many of these rulings that by now I'm just waiting for when this argument comes up. The argument is, in the case of agenda, for instance, that the Netherlands is just a small country, right? That even if it did everything it could, even if it spent all its budget on climate action and radically reduce its emissions, then that will not make a dent on the problem, because China and the US and Brazil and Indonesia, bigger countries, will continue to pollute, and the planetary effect of climate change would not change. In fact, it might get worse. Right? If you, in the case against Shell did exactly the same. The cases against Exxon or BP or Total in France, in the UK, or in the US. What government lawyers, what the corporate lawyers say is, well, why are you picking on Exxon or Shell or BP? We're just one actor. We emit 1.4% of global emissions. If we stop drilling, like literally overnight, the planet will continue to warm. So why focus on one actor? You need to go down the route of international negotiations. You have to work your way through the kind of the patient and slow route of a global agreement, and the slow and excruciating glacial pace of progress at annual COP meetings. I've been to many of those, and I decided not to go back to those because I know that Australia is trying to host the one in 2026. Good luck with that. Nothing happens. Nothing happens because it's been taken over. So it's been taken over by the fossil fuel lobby, and because governments also have reneged on their responsibility to move forward and to ratchet up their commitment and their action against climate change as they promised to do 10 years ago. So when I first started doing this research and participating in some of these legal challenges, some colleagues of mine at NYU and elsewhere who were very committed and in fact experts in negotiations, they would attend like religiously all the COP meetings, and they did fantastic work and continue to do fantastic work, let's say, supporting, providing legal advice to Pacific Island nations. They were kind of tolerant, but very skeptical about litigation, because they would say, well, you are not going to solve climate change one lawsuit at a time. This is a planetary challenge that needs a planetary solution. So in theory, I think that that's an impeccable argument. But I'm enough of a sociology and a practitioner to know that that route is not working and that the system is broken. And they will recognize that too. When you ask sincere participants and observers, they will tell you that the implementation of the Paris system failed, right? 10 years later. Emissions have continued to rise instead of gone down. And you may have seen what happened in Azerbaijan just now. Even the watered down language of phasing out fossil fuels that came out of the Dubai COP, some big countries try to backtrack on that commitment, and there's no new money invested in loss and damage or in any form of serious climate action, right? So given that that's the situation, I'm saying, well, this is an all hands on deck situation. So let's do litigation, let's do campaigning, let's do also for more patient souls, they should continue to go to the COP meetings and try to make some progress there. And at the same time, that means that every individual actor should be held accountable. No matter what the other individual actors do. And some of the best rulings in this body of case law say just that in very sophisticated terms. So both the agenda ruling and the Neubayer ruling say all of that beautifully. They say basically that they flip the consequentialist arguments on its head. They say that for the climate, for the Paris Agreement to work, there needs to be a relationship of trust among governments. And no government is going to trust others if those other actors don't do their part. So the Netherlands needs to do its part to foster trust with other governments, just like the US should do the same. Good luck with that now, and Brazil and Indonesia and so on. At their level of responsibility, as you know, one of the key principles of the Paris Agreement is common but differentiated responsibilities. Not everyone is equally responsible. Not everyone needs to contribute at the same level. So this is crucial, and it is very much in line with human rights norms and values. The fact, just to put a more mundane but serious example, the fact that you cannot be excused from the duty as a government not to torture your citizens, alleging that other governments are torturing their citizens. That's not an acceptable excuse. So likewise, human rights courts have said, no matter what other governments do, you have a human rights-based duty to cut carbon emissions and fund adaptation and then loss and damage. I'll end with this, which is blind spots. One is adaptation. 90% of the 410 cases relate to mitigation. This is why I've been talking about mitigation on and on. Curiously enough, adaptation, which is not adaptation, has to do with measures to deal with the consequences of climate change that are already inevitable, right? Mitigation is about avoiding the consequences of climate change that can be still avoided. Adaptation is dealing with the consequences of extreme weather events, of floods and droughts and tornadoes and typhoons and so on that are already inevitable, sadly. And so erecting seawalls, relocating communities, providing housing in places that are safer than the ones that vulnerable communities tend to live in, and so on. That's adaptation. Adaptation, for those of you who've studied or practiced human rights law, you would understand that this type of claim is much more amenable to human rights arguments and norms than asking a government or a corporation to cut down emissions, right? Because in adaptation claims, you would be representing a community that was forcefully displaced by an extreme weather event. So the claim is for the government to, the request is for the government to find a new housing for this community, right? Or as in one case that was litigated against Australia by the Torres Islanders, the UN Human Rights Committee said that Australia needed to step up its contribution to adaptation measure in the Torres Island because otherwise the Torres Islanders' right to life and cultural life would be fatally affected. So adaptation is an open horizon for human rights litigation. And it is a particularly kind of glaring blind spot because adaptation is the main issue for Global South countries, right? Global South countries are not supposed to contribute to make most contributions against mitigation, right? They're not the ones who should be cutting down emissions fastest. They should do their part. They also they have responsibility. But for them, they're dealing more with the consequences of climate change already, even though they contributed the least to causing the problem. And the other, and likewise, I don't have a bullet point on loss and damage here, so I'll add it here informally. The third pillar, or the third type of claim in climate change law, is loss and damage, meaning compensating the victims of losses that cannot even be adapted to. When your home and your homeland is lost to the sea, right? There's nothing you can do to adapt to that. So there's if that's the place where you used to practice your religious beliefs, if that's where your cultural life was associated with, right? It was what made possible the practice of your rituals and of your ceremonies. Well, that is no longer an issue that is amenable to adaptation claims. There needs to be compensation, reparations. And this is the global justice issue of our time, because many communities around the world will be irreparably harmed by climate change. Right? By 2050, the UN estimates that up to 1 billion people will have been displaced by climate change. So it's of course, these are all sovereign numbers, but it also means that there's a frontier of justice that has been left unexplored, and global North countries have been adamant in not allowing any language on loss and damage until very recently in the COP agreements, because they know that claims would be huge and the historical responsibility would be huge. This is so, I know that there's conversations, debates in Australia, just like in many other countries, about reparations. So this is basically the same debate at the global level, reparations for Global South countries for loss and damage. And finally, one big gap in this field is corporate liability, litigation that targets corporations as opposed to states. There's interesting action happening all the time. Banks have been sued. Carbon majors, meaning large fossil fuel companies, have been sued in the US, in Europe, a few in Latin America. But relative to the contribution of those corporations to causing the problem and to also obfuscating the evidence that they had about this issue back in the 1960s, some of them in the 1970s, some others. This is a frontier for human rights litigation. As students in my class on business and human rights know, one of the reasons why this blind spot exists is because the human rights architecture is much less robust when it comes to dealing with corporations than when it comes to dealing with governments, right? So this is still an open-ended question. I think I'll leave it there. There's much more, and it's a 20-year history, but I'd rather keep it to those blind spots and then open it up to questions. Thank you.
I'm conscious of time. It's now only 7:15. So we've gone beyond time. I see from the raise of hands before, there's so much interest here. In some respects, it'd be nice to have a 2-hour seminar. What I will say is that César's coming back next year. So hold on to that thought as well. But I do want to let him, he's been teaching for 5 days straight. I'm conscious we don't want to ask too much. So can I sort of wrap it up by saying, thank you, César, for sharing your insights. I've been sort of taking notes. And it reminds me in some ways, there's a person called Brian Stevenson, who you may know, who works in a very different space around human rights, but refuses to allow for Black African Americans to sort of be left in prisons. And he has this story about hope and the idea that words can save lives. And he then is constantly being innovative and entrepreneurial in the way in which he uses the law to try and sort of release people from incarceration. In many ways, you're giving a similar story in a very different area as well. So that it's a struggle, which is what you talk about in your work, the idea of deep time rather than short time, but one of hope as well. And the idea of collaboration, innovation, creativity, and the value of law and human rights is very reassuring to someone like me, and perhaps to those in this classroom as well, that even though this is an extremely complex problem, there is a role to play for people like César in terms of field lawyering, but also all of us as well, whether it's pressuring our universities to take different steps as well, to using whatever laws we might have to agitate for change locally, internationally, and regionally as well. So thank you so much for sharing your insights. We'll have to now read the book, of course, to get the whole picture and whole story, but thank you so much for the work you're doing for coming to Melbourne. It's a long trip, and conscious of asked much of you as well. Thank you for those who've come this evening. Really grateful for your time. Apologies we didn't get a chance to answer your questions. Feel free to email me and I can forward them to César and we can have an ongoing conversation. One of the things about having César is that I'd like to think we can continue this conversation with the work he's doing at NYU in the future as well. So when I did joke about him coming next year, one of the incentives would be to have these sort of forums. So we could be having longer workshops. We think more strategically, more creatively about what to do next as well. So thank you. Good luck. Have a wonderful Christmas. Stay safe as well, and have a wonderful break over the new year too. Please again, thank you, César, for his contributions this evening.
Thank you.
Thank you.